Everyone, and welcome back to our conference. So we start the session for international law. May I invite Professor Robert Volterra, partner of Volterra Fietta UK, to chair the session. Thank you.
Thank you and good morning, everybody. We have now the law panel, so we're going to be turning to look at international law and relevant aspects of international law. I am moderating this first session of the morning, and with me up here and speaking in the order in your presentation packs will be Professor Alex Oude Elferink. He's the director of the Netherlands Institute for the Law of the Sea at Utrecht University. He also has a professorial position up in Norway. After him will be Dr. Nong, who's the director of the Research Center for Oceans Law and Policy at the National Institute for South China Sea Studies and an executive director of the Institute for ChinaAmerica Studies. Then will be Mr. Bill Hayton. Apparently, I'm not speaking loud enough. I apologize. After Dr. Nong Hong will be Mr. Bill Hayton, who's an associate fellow at Chatham House. And finally, Dr. Vu Tan Ka, who's associate professor and director of the Research Institute for the Management of Seas and Islands, Vietnam Administration of Seas and Islands. And after that, we will be taking questions before the coffee break. I have been asked to keep all the speakers to their 12 minutes, and so I will be ruling with a fist of iron. Before I call upon Professor Elferink, I wanted to spend a couple of minutes setting the stage now that we're turning to the law. We're going to be talking, of course, about public international law, and public international law is the law that governs relationships between countries. There are two sources of international law, and I thought it worth explaining what this is. We have a lot of friends here who are not lawyers and not public international lawyers. The two sources of the law are custom and treaty. Treaty is very clear. It's like the Law of the Sea Convention. It's written out, you can see it, and it applies and binds the parties who sign and ratify it. Custom is different. It is identified through a number of sources, but largely revolves around the way states behave. And you can get a customary rule of international law developing if enough states for enough period of time act or don't act in a particular way because they think they are obliged by law to do so. So it's essentially looking at state activity. So you can have law, public international law that's written in treaties, like the Law of the Sea Convention, and public international law that is developed by custom and the practice of states. This is very important when talking about the Law of the Sea, because whilst we are all familiar with the Law of the Sea Convention, that is only one source of international law that deals with issues like we are talking about today and the South China Sea. There's also customary international law. And much of the Law of the Sea Convention, particularly relating to sovereignty and, not sovereignty, but boundaries and allocation of rights and responsibilities in maritime zones, comes from customary international law. And the Law of the Sea Convention merely codifies it, merely brings it together. So the methodology, for example, for delimiting maritime space is referred in the Law of the Sea Convention directly to customary international law. There are no specific provisions in the Law of the Sea Convention dealing with this. It's important to know because there were some concerns expressed yesterday about whether the United States was a ratified party of the Law of the Sea Convention. Well, even if they're not, most of the bulk of the Law of the Sea Convention still applies to them, not just because they've signed it and have an obligation in law even if they haven't ratified it, but because of the content of customary international law. And the only last thing I'm going to say about this is it's very clear in international law that it's not possible to have sovereignty over maritime space. You can't have sovereignty over water, with one exception, and that's the 12-mile territorial sea. And that's specifically set out in the Law of the Sea Convention. That is customary international law. It's very expressly written. So you can have, a state can have sovereignty up to its 12-mile territorial sea limit. After that, all that states have in terms of individual state rights is rights to regulate the economic use of the water and seabed. That means that traditional, customary international law rights of passage, military or otherwise, and so on apply nonetheless, even if a state has a right to regulate economic activity up to 200 or more nautical miles. And that's important to remember. So there's the law of the sea convention, there's also customary international law, and in terms of sovereign rights, it doesn't matter how many dashes you write on a map, you can't get sovereignty way out in the sea. So with that, I hope I've set a bit of the stage, and I now call upon Professor Elferink to give the opening presentation this morning.
Thank you, Mr. Chairman, also for that introduction. Very useful, I think. I would also like to thank the organizers for inviting me to this conference. This was very interesting. I hope we can continue the high level today with law sessions. So that's the title of my presentation states I'm going to talk about the role of international law in the South China Sea disputes. And more specifically, in my paper, which is yet to be written, I'll be looking at two questions: how international law is argued by parties to the South China Sea disputes, and what that tells us about the role of international law in dealing with specific issues, and how law may influence state behavior. Of course, it's very complex, all the issues in the South China Sea, so I decided to look at three specific issues. So the first one is the Haiyang incident of 2014, and then the 2015 USS Lesson, passages in the waters of around Subi Reef, and then finally the Annex 7 arbitration. And today I will just discuss some of the aspects of the first and third issue, because otherwise I would be well over my time. So let's look at the first incident. So first, some of the background, of course, familiar to most or all of you. It was operating beyond the territorial sea of the Paracel Islands, licensed by China and protested by Vietnam. So those are also the parties that are most relevant to look at in this case. And so this is just to give you the location, and also maybe I included these two maps. One is from a Chinese document submitted to the United Nations, to the writers from Wikipedia, and I think it also shows you, illustrates how states can use maps to convey certain messages, because in the left hand, the two red stars are the locations of two drilling locations, and they seem to be well located in the Paracels, very far from the Vietnamese mainland. If you look at the other picture, you get a very different impression. So interesting how states also use images to convey certain messages. Also interesting in this case is that you could say there is a bifurcation of legal arguments. So on the one hand, there was a discussion on the sovereignty dispute over the Paracel Islands, and I think that mostly concerned a revisiting of existing arguments without any further development. I think on the other hand, if you look at the dispute over the activities of the Haiyang, there was some development of the legal argument also in response to each other's arguments. So I think that was interesting to note. So first the Chinese perspective. So first of all, China seeks to present this as something that is a routine operation. Well, you can argue, of course, about that, obviously. And then also they said it was a continuation of ongoing activities. So again, suggesting that this was business as usual. And then they also refer to the distance. I would say also in this case, not really that relevant in itself for determining who eventually would have jurisdiction over these activities. And in any case, it does not dispose of the question who has sovereignty pending, or who has the right to regulate activities pending delimitation. And so also there was characterization of the actions of Vietnam. And also Vietnam was asked to immediately cease its actions. And so also another characterization as undermining proper order at sea. So also invoking a higher order interest, you could say. And also interesting, there was also a reference to delimitation. Two things are interesting because it recognizes that there is a need for delimitation, but it's indeterminate on the status of the Chinese waters if you look at the formulation. But in any case implies that the 9-dash line, I would say, implies that it's not considered to be a maritime boundary, because otherwise there would be no need for a maritime delimitation. And subsequently China was even more specific, because then it stated that the two sides have not yet delimited their exclusive economic zone and continental shelf, so indicating that on both sides of the boundary there would be an exclusive economic zone and continental shelf, and so not a delimitation of historic waters or something like that on the Chinese side. So quite an interesting submission, I would say. So also the Vietnamese perspective, of course, completely opposed from the Chinese, so operating in the exclusive economic zone continental shelf of Vietnam, and also reference to the declaration of conduct, other relevant agreements, and also of course the demand that China pull out the rig, and also a request to cooperate, and also this reference to this broader issue of peace and stability. And also Vietnam responded to the fact that there had been prior activities. Those had been protested by Vietnam. And also it noted the actions of China. And finally also, like China, it referred to the need of delimitation. But just like China, it took the position that whatever principle applied, the area concerned could never be part of Chinese waters. So in that sense, the states basically radically were completely opposed. Also interesting, there's one, I would say, missing legal argument, because of course there is a delimitation dispute. If you look at both of the positions, they both characterize it as a delimitation dispute. And of course in that case there's also, you can have reference to Article 74.3 and 83.3, which I quote here. And also, of course, this incident raises issues of compliance with this provision, and you could argue that on both sides it raises issues of compliance. But, well, interesting that it was not mentioned at all, but I think also logical because of the way that the legal arguments of both sides were structured. So the Philippines versus China arbitration, and in this case I intend only to look at general aspects and not at all the detail of the argumentation during the pleadings of Philippines. But if you look at Philippines, how they stressed it, first of all they put this emphasis on faith in the rule of law, and law also they say is an equalizer. And in particular the UNCLOS, the Law of the Sea Convention, and they also stress this fact that it's a constitution for the oceans. And also part 15, which of course has to do with dispute settlement, was characterized as vital even for the equalizing power of the UNCLOS. And also, of course, they say UNCLOS does not recognize historic rights. I'll say something more about it in my next slide. And they argue that all maritime entitlements are governed by UNCLOS. So basically no possibility of claiming historic rights once you've become a party to UNCLOS, is what the Philippines is saying. And even conflict with the very character of UNCLOS. And then finally also this reference again to the, yeah? Okay, I'll use this one. Is this better? Well, I'll use it in any case. And so also again this stress that it's of utmost significance for the integrity of the convention. So there's a lot of emphasis in the Philippines position, not only on the bilateral character of the dispute, but also for its wider significance for the international community. So the Chinese position, based mostly on the Chinese position paper, but also on a statement after the award on jurisdiction and admissibility was issued. So the Chinese position, the essence of the dispute is territorial sovereignty, and of course that implies that you cannot deal with it under the convention, because the convention of course is only concerned with the interpretation, application of the convention, its dispute settlement provisions. And also there is this stress that there was an agreement to negotiate and not to resort to third-party dispute settlement unilaterally. And otherwise it's also argued that the subject matter is an integral part of maritime delimitation. The implication of course being that because China has made a declaration that it excludes maritime delimitation from compulsory dispute settlement, that the whole claim of Philippines cannot be entertained because there is no jurisdiction of the tribunal. And that's then the conclusion of the of China. And China then also argues that it's non-participation because of that, because there is no jurisdiction. There's a solid basis in international law. That's debatable, of course. And also in this stage, at least, I think that it's different. The position of that China takes, or the way China argues, is different from the Philippines in the sense that it focuses on the bilateral character of the issue and not at the international dimension, which Philippines in its application and pleading was emphasizing very much. And so this is then what China said after the award and jurisdiction admissibility. It stresses it's null and void and has no binding effect on China, logical consequence of its earlier position, I would say. And then the second statement I think is more interesting because in this instance it not only takes issue with Philippines but now also with the arbitral tribunal. And so basically you say that it's an abuse of relevant procedures, misrepresentation of the law. And now also there is this focus on, let's say, the international community interests, because it says it deviates from the purpose and objectives of the UNCLOS, and also has even eroded the integrity and authority of the convention. So that's a different approach that China now takes after the award in comparison to the approach it took before, I would say. Maybe a little more about the issue of historic rights, because it's also been discussed here a lot, quite interesting. So, position of the Philippines set here out, and this is from the pleadings, oral pleadings on jurisdiction admissibility by Counsel Reichler for the Philippines. And so basically it says that you cannot claim historic rights when you're a party to the law of the Sea Convention. And interestingly also, there's a lot of talk also about the positions that the US takes. This is a publication of by the United States Department of State, Limits in the Seas, very authoritative, and there's a recent publication on China maritime claims in the South China Sea, and it also refers to the drafting history and the case law in this case to reach more or less the same conclusion. And that's quite interesting because it gives the impression that it's a very detailed argument, but however, if you look at it, it's interesting that both do not mention, I would say, the most relevant case as far as historic rights and historic waters are concerned, and that's Tunisia-Libya, and that basically says the opposite of what Limits in the Seas and the Philippines are arguing. So interesting how, even in a very complex argument, you can just gloss over the most important case. So, and also, if you look at the UNCLOS, of course, that's in the preamble, it also refers specifically to that matters not regulated by this convention continue to be governed by the rules and principles of general international law. Well, historic rights are not governed by the convention, so it's general international law, like Robert also said, you have to look at. So some concluding thoughts. There's some interesting, some legal arguments are developed in these cases, not so for other legal arguments. Of course, interesting to look more in detail what specific arguments is concerned. And so, as I said, China in the arbitration moved from a bilateral procedural focus to include also a systemic focus on the significance of the convention for the international community. Another point is key legal arguments may be neglected, and that in a largely depends on how states frame the issue. That may exclude making certain arguments because they do not fit your overall position. Legal arguments are also in general presented in a broader contrast, for instance, peace and stability, or interest of the international community, interest in trade, international communication, and of course that's always to further justify your legal positions. Also legal arguments are of varying quality, I would say, and also the level of detail is not necessarily linked to the quality of the argument. And so the final question, of course, does it have an impact? I would say it does in a way, because states in any case structure their argument taking into account international law, but of course it's just one input in the whole policy process, so the impact is also limited in that respect. And of course I think one of the most interesting questions is, of course, what do key policy makers make of international law, and in particular when are they informed about what the, let's say, an objective reading of international law would imply. And of course that has a big influence on, may have a big influence how policymakers approach certain issues, because if you're only told about the law in a fragmented way or too late, you will not take it into account in your policy to start with. I think that's a good concluding thought. Thank you for your attention, and thank you.
Good morning, everyone. Although I have only 12 minutes, but I would like to start thanking the co-organizers, for especially Ambassador Dr. Dan, for having me back to this conference. I was required to write a paper on the two concepts, history of water and history of right. By agreeing to make this presentation, I'm thinking I'm taking the risk of putting myself in a hot spot as well. So what I'm going to do here is today is, well, obviously the core issues among the claimant states, especially between mainland China and Taiwan as well, and also other claimant states, is actually the overlapping or conflicting interests. On the one hand, we have these historical demands versus other modern demands, such as the concept of EEZ and continental shelf, and also island regimes under law of sea convention. So the question here is for debate is whether the historic doctrine is still relevant in contemporary international law. To begin with, and I think we have on the South China Sea issues, so we have a lot of legal questions, such as the islands regime and the effect of islands on maritime delimitation, and also provisional measures pending the final delimitation, and also cooperation in the enclosed and semi-enclosed sea. All these issues, although we have different interpretation from different claimant states, but actually you can refer them to provisions in the law of convention. But the issues of historic water and historic right, and absolutely, and you will not find any definition on these two concepts on the law of convention. The only three articles that might refer to the historical concept is on Article 10 on the historical base, and also Article 15 on maritime delimitation of territorial sea, which the concept here or titles referred in this article, and which is also again referred to in the Article 298 on Part 15 of Law of Convention. So what is the definition of historical water first? And there are many definitions. I think one of the best could be the one that provided by Volterra in 2008, which the historical water refers to waters over which the coastal state, contrary to the generally applicable rules of international law, three preconditions: clearly, effectively, and continuous and over a substantial period of time, exercising the sovereign rights with acquiescence of a community of states. Or in other words, it refers to the areas of waters, the legal state of which differs, and again, with the consent of the other states, from what it ought to have been according to general recognized rules. And there also exists the separable term of historical right, normally in a high sea area, but without any connotation as to sovereignty in locales, such as historical fishing right. And what are the differences between these two terms? And the first difference will be the claimed historical waters must necessarily be adjacent to the claimant state. But for the historical right, which has a broader sense than historical waters, do not actually amount to zonal claims of jurisdiction or sovereignty, or it's merely based on respective rights by long usage. So then I would like to talk a little bit about the historical concept and the maritime delimitation issues. The presence of historical concept may affect the drawing of a maritime boundary, and which is reflected in Article 15. The delimitation of the territorial sea requires adjustment of the median line where it is necessary to take account of historical title or other special circumstances. And despite the reference to the historical title in Article 15 and the role of historical fishing rights in the delimitation of EEZ is not clearly spelled out in the Law of the Sea Convention. However, the relevance of historical usage and economic dependencies to boundary delimitation of fishery zones has been recognized even prior to the Law of the Sea Convention since fishing resources, unlike hydrocarbon resources in the continental shelf, have been exploited for centuries. And another issue, historical rights were recognized in the determination of maritime boundary by the third parties, and one of the famous cases is the Wiesbadener case. In the limitation between Sweden and Norway, the Permanent Court of Arbitration decided that the Wiesbadener area should be assigned to Sweden. One of the reasons for this delimitation was that the circumstances that lobster fishing in the shores of Wiesbadener has been carried out for a much longer time and to a much larger extent and by much larger number of fisheries by the subject of Sweden than by the subject of Norway. So to step back, historical rights, even if considered irrelevant to delimitation issues, may still be independently taken into account by special agreement as to assets, which is reflected on their arbitration case between Barbados and Trinidad and Tobago. And then the next question I would like to discuss is the historic concept related dispute settlement under Law of Sea Convention. And Article 291 actually exclude issues such as delimitation of territorial sea, EEZ in continental shelf, and also historical title from a third-party forum dispute settlement, so which give a state the right to exclude those very sensitive issues from a third-party forum mechanisms. And however, the claimant state, the competing claims over the existence of historical rights cannot easily be resolved under the term of Law of Sea Convention. And the very specificity on the standard to be applied in determining claims to historical title was avoided in Law of Sea Convention for similar reasons as maritime delimitation. So it's quite obvious that Law of Sea Convention deliberately avoids the issue of historical rights or historical waters, leaving to be governed by general or customary international law as reformed in the preamble in the Law of Sea Conventions. And the next question I would like to discuss, and maybe it's necessary for debate, is whether historical doctrine, be it historical water or be it historical title, what is still relevant in contemporary international law. And there are different arguments. Let me just quote a few which might have different understanding about this issue of doctrine of historical demand. And the first one is by Frenchers in 1985. And he said, the long-standing practice evidenced by a strong historical presence should not be disturbed. And judicial bodies are ill-advised to disregard a situation that has been peacefully accepted over a long period of time. And then Clyde in 2005, she made an argument that it's arguable that historical rights should be admitted in a more restricted fashion now that because the coastal state has much broader entitlement to maritime jurisdiction given by a Law of Sea Convention. And states might be inclined to challenge the declaration of historical title in certain area if such a declaration imprints on exclusive uses of that region. So, and alternatively, a challenge may arise in a bilateral delimitation where the historical claims has the effect of enlarging the entitlement of states within adjacent or opposite coast. And then, now back to what is China's historical claims in the South China Sea, which is an unclear question with no clear answer. So the most important and interesting area that where China might claim historical rights is in the South China Sea. The prevailing basis for China's historical claims to the South China Sea is the U-shaped line officially drawn on the Chinese map in 1947 by the then Chinese nationalist government. And Taiwan authority gave the status of a historical water to the areas within the U-shaped line in 1993 when they issued the South China Sea policy guidelines, but it tends to not to use the term historical water anymore after 2005. So the question of, actually there was a debate question whether the there's effective control over the area within the line so as to establish it as a historic water, which is a question. But the non-existence of historic water in the traditional sense in the South China Sea actually does not necessarily mean that there exists no historic rights of any kind. So it's quite clear from Chinese stance that it seeks to enjoy historical privilege of some kind in the South China Sea. And the most convincing rights that China could enjoy are fishing rights. And in the 1998 Chinese EEZ law, and there are three interpretations about what could historical rights mean. First, it can be interpreted to mean that the sea area in question should have the same legal status as areas under the Law of Sea Convention. And second, it can be interpreted to mean that certain sea areas to which Chinese historical rights are claimed to go beyond 200 nautical miles. And third, it can be interpreted to mean that the sea areas to China's historical right apply within 200 nautical miles, but will come under alternative national management regimes. And then now we have this Chinese historical claim in South China Sea based on U-shaped line overlap with the claims of EEZ and connection with other claimant states. So in China's view, a claim derived from historical rights may seem more forcible and valid in law than claims simply only based on the concept of EEZ. So since there's no definite rules in international law which govern the status of maritime historical rights, and China's claim is not a violation of international law. But similarly, since there are not such rules, it's also doubtful whether Chinese claim could be established in international law. So the question of whether the doctrine of historical counsel is still relevant is a question that will bring to my last slide. How to look at the best way to view the past claims. The role of historical rights in maritime delimitation seems to receive a various amount of attention. However, even if historical rights and economic dependencies on fishery only result in a minor adjustment of maritime delimitation, the issues of fishing rights are still important factors to be considered by states. So the question, however, is how to balance and how to reconcile the existence and recognition of historical rights with the EEZ regime contained in the Law of Sea Convention, which is binding on all states. So the last key concept is the non-exclusive. So one of the reasons why the claims to historical fishing rights are not normally related to maritime boundary is because such historical rights are not exclusive. For instance, for China, if China's claims of historical fishing rights is recognized, and such recognition does not actually preclude the rights of other claimant states in the South China Sea, either based on the EEZ concept or historical fishing rights. And with that, I will finish my presentation. I welcome your comment later. Thank you.
Thank you very much to the organizers. It's nice to be back in Vietnam after a long time away. These are my own views, not those of the BBC or Chatham House. Can we have a slide up? Can I wait for my 12 minutes to start now? Right. Where does the U-shaped line come from? Okay. I would argue that this is the origin of the U-shaped line. In the 1920s and 30s, various Chinese nationalist dreamers produced a number of what are called maps of national humiliation to try to show the amount of land that had been stolen from China by imperialists over the ages. And you can see a map here from 1927 showing a Chinese claim on lands as far west as Iran, including the whole of Southeast Asia, plus bits of what is now Russia. These were dreamers, people like Bai Meichu, the founder of the China Geographical Society. And they took, in 1936, Bai Meichu took a map, a British map, and he translated the names into Chinese, and he drew a line around it, suggesting that this was China's historic claim. Unfortunately, when he translated the names, he made some mistakes. So the James Shoal in the southern part of the sea became the Zhengmu Tan. Zhengmu is simply JM, the English name, James, transliterated into Chinese. But he didn't know how to translate, well, a Republic of China committee in 1935 didn't know how to translate the word shoal. So he used the word tan, which means sandbank. And he invented an island that doesn't exist. And you can see it marked down here, Zhengmu Tan, sandbank. It doesn't exist. The James Shoal is underwater. But by an administrative cock-up, a translation mistake in 1935, China thought that the James Shoal was land and drew a line around it. And that is the origin of the U-shaped line, okay? It's a historic mistake, but unfortunately it's a mistake that 1 billion people now believe. And the problem is that whenever anybody talks about UNCLOS, a Chinese audience just thinks it's an imperialist plot to take away a historic right, like this. So how do you convince 1 billion people that they are wrong? The problem is that a lot of this myth-making has now snuck into the English language. The first English language analyses of the South China Sea disputes followed after the invasion of the Paracels, or the western half of the Paracels in '74, and many more have appeared since. But what I want to show you with this slide, not that you'll be able to read all the writing, is that so many of the English language references, when you trace back the sources, go back to these early papers written in the early 70s. So a paper by Tao Cheng for the Texas International Law Journal was followed by another by Hongda Chu and Chunhu Park, both in '75, and then Dieter Heinzig wrote another in '76. But they were pioneering, but all their sources were Chinese. Cheng's paper relied primarily upon Chinese magazines from the 1930s. He didn't reference any French, Vietnamese, or Philippine sources, with the exception of one French article which had been translated into Chinese. Chu and Park relied upon similar sources, Chinese articles published in 1933 and 34, supplemented with material from a 1948 Shanghai publication. The names are all in the longer version of the paper that I've written. So these are the early works. And if you go and look at the actual papers and check the footnotes, I'm not expecting you to read this, you will see the names of the Chinese sources that he uses. And Chu and Park's sources are the same, or similar. And Heinzig himself, he used a couple of Hong Kong publications produced in 1974 in the immediate aftermath of the Paracels battle. Now, my argument is that all of these foundational papers are based on Chinese media articles published at times when discussions about the South China Sea were highly politicized. 1933 was the year when France annexed several of the Spratly Islands, provoking anger in China. 1956 was when Thomas Clomer, Philippine businessman, claimed the Spratlys for his own country of Freedom Land. 1974 was the year of the Paracels battle. So newspaper articles published in these periods should not be expected to be neutral, dispassionate sources of factually accurate history. They should be seen as partisan viewpoints. So I'm not saying they're automatically wrong, but any assertions in these articles need to be checked with other sources, and these authors did not do that. And you can see more, these are more the names of the articles. So Marwin Samuels is still a foundational text, a book published in 1982, but he made all the same mistakes. He used the same kind of sources, Hong Kong magazines from 1974, and also acknowledged that he used a lot of the Taiwanese archives. But unfortunately, most of the interesting stuff in the Taiwanese archives was only made public in 2008-9, a quarter of a century after he wrote his book, and it hasn't really been updated since. The 1990s, there was another flourish of history writing. So the former US State Department geographer turned oil sector consultant Daniel Jurek wrote a paper in '96. Greg Austin, the Australian, his book came out in '98, and Chris Joyner from Georgetown University wrote an important paper in 1999. Dan Jurek, by the way, is the guy on the left here, and there he is advising the Crestone delegation on its oil contract with the Chinese government there in 1992. Then along comes a major paper in the sense that it's had a lot of influence. A guy called Jianming Shen, who's a Chinese-American attorney with an affiliation to St. John's University School of Law in New York. And in '97, he published a key article referenced many times in the Hastings International and Comparative Law Review. Now, like the Texas International Law Journal, this review is a student-edited publication. Okay? Now, my argument is that an editorial board composed of American law students may not be the best group of people to scrutinize works of Asian maritime history. Nonetheless, this journal continues to this paper continues to set the agenda. For example, a 2014 paper published by the US federally funded think tank, the the Center for Naval Analyses, references Shen's work 170 times. But if you look at where Shen's sources are, they are coming primarily from two main sources. One is a book by a guy called Duanmu Zheng, there's his picture on the right there, and another is a seminar that was held in Beijing. A collection of papers from the Symposium on the South China Sea Islands, organized by the Institute for Maritime Marine Development Strategy. Now, what's interesting about Duanmu Zheng is that he was the vice president of the Chinese Supreme Court and one of the drafters of the Hong Kong Basic Law. He was a Chinese legal official, a state official. He was not a neutral historian. Okay? All the references in Shen's work come from 2 pages of Shen's book. There they are, those 2 pages there. There are no references to any other sources on those pages. They're simply one man's thoughts about the South China Sea. It's not a work of history. What's ironic then, of course, is that this symposium, which is the other source, which is part of the Chinese State Oceanic Administration, so their information has been filtered through Shen, has been filtered through the CNA's paper, and is now part of the Pentagon's understanding of the history of the South China Sea. All of the authors that have written on this were political scientists, lawyers, IR specialists. They were not maritime historians. They don't challenge the integrity of the text that they quote, nor do they discuss the context in which they were written. It's also worth noting that Cheng, Chu, and Shen were Chinese-born. Cheng and Shen both had LLBs from from Peking University, and Chu graduated from the National Taiwan University. This doesn't necessarily make them biased, but I would argue that they were more familiar with the Chinese point of view than other points of view. Let's look at some practical examples. So Samuels, for example, argues that an implicit Chinese claim to the Spratly Islands might be dated to 1883, when in his account the Qing government officially protested against a German state expedition to the Spratly Islands. And his assertion is sourced to the May 1974 edition of Mingpao Monthly, published in Hong Kong, published 91 years after the events it claims to describe, without any other corroborating evidence. Chu and Park ascribe it to an article published 50 years later in 1933. So, and Heinzig quotes the same edition of Mingpao. The problem is that the German surveyors mapped the Paracel Islands, not the Spratly Islands. So the idea that the Chinese chased away the Germans from the Spratlys is just nonsense. Moving on, there are many claims that there was a Chinese expedition to the Paracels in 1902 or 1907. Austin and Jurek, both, and Samuels also suggest this, and Chu and Park make reference to a 1907 expedition. But some Chinese documents that were made public in a publication from a bit later, but more recently, explain this confusion. What happened was that in 1937, with the Japanese invasion of China, China decided to shore up its claim to the Paracels by mounting a secret expedition in 1937. And they took memorial stones with dates from 1902 and planted them on the Paracel Islands. And here is the account of that expedition, of this secret mission, where they actually went and planted markers with the dates 1902 and 1907 and 1912, and retrospectively claimed historical evidence. And these markers were later discovered and claimed to be proof of the 1902-1907 voyages. And my last example would be the 1933 French annexation. There was often many claims from the Chinese side that they protested against the French annexation of 6 of the Spratly Islands in 1933. This is the annexation announcement. There is no evidence of any Chinese protest against this. Tao Cheng references some newspapers, but there is no actual protest as far as anybody can make out. And the reason seems to be fairly clear. That in September 1933, the ROC military committee decided it had no claim to the Spratly Islands. And there was indeed considerable confusion, and the Chinese government had to ask the American authorities in Manila for a map to tell them where the Spratly Islands were, and then when it realized that the Spratly Islands were not the same as the Paracel Islands, decided not to issue a formal diplomatic protest. So those are the dates of those former those expeditions. I would argue that history, the English language history, the Chinese language history of the South China Sea has been written and rewritten repeatedly over the last 100 years. Mistakes have been inserted, they have been compounded, and other mistakes have been added later on. So I would say that if you're relying in your legal analysis on any of these works, you need to think again. you need to go back and check their sources and decide whether they're reliable. I would say if you want to write about maritime history in the 20th century, you need to be looking at these people. Christopher Chung, Chinese-Canadian PhD student, University of Toronto, doing fabulous work inside the ROC archives. He will show you conclusively that the U-shaped line was never meant to enclose the waters. It was only meant to indicate which islands China was claiming. So, it's no longer good enough for people to rely on those same old sources. It's time to move on, folks.
Good morning, ladies and gentlemen. Until now, we just talked a lot about international law regarding the territory delimitation in the sea. Now, I would like to go to other topic. That is a requirement for ocean governance framework for the protection of environment and biological resource in the South China Sea for sustainable development. So, as you in fact, the South China Sea is very rich in biological resource, and international resource in South China Sea provide goods and service to social economic development of surrounding countries and countries outside the region. And many countries in the surrounding the South China Sea, such as Indonesia, China, the Philippines, Cambodia, and Vietnam, have large population dependent on fishing, and are very rich in biological resources. But nowadays, the fishery resource in the South China Sea has been seriously depleted by overfishing, illegal fishing, and destroying ecological system and habitats. For example, the coral reefs are seriously degraded, and some estimation says that almost a half of the coral reefs in the South China Sea, except in the central of the South China Sea. And nearshore South China Sea coral reefs are destroyed. And invasive species, construction of artificial islands and island reclamation. And also the pollution is very serious, and it also causes degradation of the fishery resource in the South China Sea. And the South China Sea environment also seriously degraded due to land-based pollution loads and seaborne waste, and due to unregulated use and exploitation of natural resources, or use and exploitation of natural resources not following rational planning. And also, the most important is territorial dispute prevent any effective governance mechanisms. So, the problem of degradation of fishery resources and biodiversity and the environment is worsened. Now we are going to the reason for the degradation of biodiversity and fishery resource in the South China Sea. And among countries surrounding the South China Sea, China is nowadays the largest fishing state in the world. And in 2010, according to CIA book, in 2010, the total number of licensed fishing vessels in China is about 300,000. And present, the total present fish catch of China is more than 17 million. And the next state, the second state in the world, is just only more than 4 million. So the total fish catch of China is more than 4 times the second stage in the world. And some endemic species, that one is very, very valuable for Chinese. For example, the coral groupers and Napoleon wheatgrass, in the past 8 years alone have seen 80% decline. There's some source say about that one. In fact, we must stress that due to difficulties in scientific research and without cooperation between different states surrounding South China Sea. So until now, we do not have exact figure about the biodiversity in the South China Sea. There's a lot of data, but just adjacent to some states, and we believe that those one are not really correct because mainly the work done on the surface and not at deep water. And so the reasons for the biodiversity and fishery resource degradation in South China Sea. The first one, extractive fishing method and dispute. And usually for the dispute situation, when every country seeks to gain an advantage over other, which are thinking that if we do not catch, others will do. And the U-shape up about 87% of the South China Sea area is a really problem because it prevents any coordination efforts by different states. And also the strong currents in the sea help transporting pollutants from place to others. For example, in 2007, we have in the coast of central Vietnam, in fact from the north until the south, encounters problem of oil spill. So a lot of oil spill, spill oil, crude oil, drifted to our coast, but after a very long time we could not find the source. So in that case, only cooperative efforts can solve this problem. So without concerted efforts, biodiversity and fishery resource in South China Sea will degrade until a level that may be very difficult to be recovered, and many species may face extinction if we do not act now. And the causes, as I mentioned before, above. So I would like to summarize the causes for living resource degradation and environmental pollution in the South China Sea. Weak governance in coastal states, even in states with relatively complete law system on the regulation of fishery, conservation and protection of marine living resource, and ecological systems and protection of marine environment. In fact, many states surrounding it, almost all states surrounding the South China Sea have already spent great efforts for conserving the biological resource. For example, China have issued a policy of no increase in fishing, and also other countries, for example Vietnam, we have issued a system of law for biodiversity conservation and also for the conservation of fishery resource. And the second reason is difficult for coordinating and cooperating coastal states in the regulation of fishery, conservation and protection of marine living resource and ecological systems, and protection of marine environment due to territory and sea area dispute. In fact, this one we must stress that the South China Sea is an international space, and many species of fish can migrate inside the sea, and even more than the sea. For example, some shrimp species can migrate from South China Sea until the Sea of Japan, very long distance. So to protect the fisheries resource, we must protect all the entire ecological system. We cannot separate between different countries. So we need the cooperation from all countries surrounding the South China Sea, and that we need the governance mechanism that can do that one. And large-scale island reclamation by China damages the most valuable of coral ecological system in the South China Sea. And in fact, the coral, as you know, that the coral reef can be considered as the rainforest jungle. Its biodiversity is very large, and it can provide a very large amount of fish resource to the surrounding area. And the health of the coral system can be used as a measure of the ocean health. And the coral system, a large-scale coral system, is damaged. So the damage to the South China Sea ecosystem is very large. And lack of an effective regional ocean governance mechanisms, also due to territory and sea area dispute. In fact, in the the Sea of East Asia has two international coordinating mechanisms. The first one is the coordinating body for the Sea of East Asia. We call abbreviated by COPSEA. And second one is a partnership in environmental management of the seas of East Asia. We call it PAMC. And those two mechanisms help coastal states, including China and other countries, to prevent the further degradation in the environment of the Sea of East Asia. Also, now, especially COPSEA are going in the direction of conserving the biodiversity biodiversity. However, all the mechanisms avoid, because they must make their mechanism work, so they avoid all the territorial dispute and just they apply to the South China Sea, but just near shore, very near shore, and no dispute water. So they just solve very, very small part of the problem. They cannot solve their own problem. So, in fact, the DOC said, DOC is one of the legal, in fact, not political document that requires state refraining from action of inhabiting on the present uninhabited islands, reefs, shoals, cays, and other features, and to handle the differences in a constructive manner and pending a comprehensive and durable settlement of the dispute, and the party concerned may explore or undertake cooperative activities. These may include marine environmental protection, and ocean governance is an approach for the management activity in the ocean with priority and cooperation coordination system. And the governance can be implemented at global, local, and national scales. The governance creates a common framework for management. The governance is established from constitution, regulation, and convention, international agreement on maritime activities, and on the use and exploitation of natural resources, conservation and protection of marine environment and ecological system, or for social economic development. And international conventions that can be used for development of the governance is the first one, UN clause and other conventions. And the UN clause is the most comprehensive legal documents that we can use for establishing such mechanisms. So it's necessary to have a regional effort, and there should be an appropriate mechanism for connecting the responsibility of different countries. So, in fact, it's necessary, because you may think that my speaking now is almost impossible, because now no country in surrounding the South China Sea in which draws their claim, especially China, the U-shaped line. But if we do not begin, we do not talk about this one, so we shall never go to the end. So we should talk now, and we need an ocean governance. If it works, it must need a clarification of sea area under state jurisdiction and high sea. And in fact, we now claim no high sea in the South China Sea. The mechanism is not possible now, but and just of the permanent code of arbitration in the case of Philippines versus China may help determine the legal status of a U-shaped dotted line that enable China to settle abroad claims. And we have some hope. The first hope, according to my view, China is a large and powerful and responsible country. And Chinese scholars may help the government to understand the real situation and take appropriate actions. And conferences, workshops, open-ended consultation process like the UN's open-ended consultation process on the law of the sea may help determining detail of the coordinating and cooperating mechanisms. And hope and try our best. Thank you.
Well, my thanks to all of the speakers. We've had 4 excellent and thoughtful presentations. Started off with Professor Elferink, who gave us a forensic examination of the role of the South China Sea arbitration right now before an Annex 7 tribunal, analyzed a few of the claims of the parties, came to some interesting conclusions, including that that China seems to be moving from a bilateral expression of its international law views to perhaps a more systemic challenge view. Dr. Nong Hong talked to us about the legal concepts of historic bays, historic title, historic fishing rights, and contemplated whether all of this contributed to a concept of historic waters and what effect that might have on the South China Sea claims. We then had Mr. Bill Hayton, who presented the astonishing proposition that perhaps facts make better historical records than fiction. And then finally we've had Dr. Wu Tan Ka, who gave us a very clear series of proposals in favor of the concept of ocean governance in the South China Sea, pointing out that there should be a public international law framework for environmental protection to ensure biodiversity and prevent species depletion. So now it's time to open up to the floor for questions and comments. In the fashion that has been followed so far, I'll look first to what's been called the inner ring, and then after that to the outer ring. And I'm sure there'll be plenty of time, and so please just indicate to me if you'd like to make a question. I think there was a gentleman here.
My question is for Bill Hayton. I'm Chairman from ISIS Malaysia. Bill, I'm wondering if you've had a chance to do this presentation in China in front of expert Chinese audiences. I'll be interested in knowing what kind of responses you've had. What are the key arguments that they try to put up against what you've presented?
I've given it, well, something similar, but only to the Foreign Correspondents Club in Beijing, so I'm afraid the Chinese people didn't have the benefit. But I'm very happy to go and do so in either part of, in any part of China, shall we say. I mean, I'm open to evidence. If people have got better evidence, I mean, I have all of those 1930s, 1970s newspaper articles on my laptop here. If anybody wants them and can read the Chinese or get it translated, I'm very happy to share it and be proven wrong if necessary.
Thank you. I'm Michael Gao from Taiwan, National Taiwan Ocean University. I think it is very important to know the claims of the parties, and it is also the purpose of this South China Sea arbitration to push China to clarify the positions of historical title, historical rights. But as an international lawyer from Taiwan, I cannot help but providing some of the claims made recently by Taiwan government. And Taiwan government's claim is very important because Taiwan government is considered to be the ancestors of the Beijing government. And Beijing government, when facing the challenge from South China Sea bordering countries, will always say that the South China Sea claims has been left by our ancestors and we cannot yield, we cannot surrender lightly. So I think it's very important to know what Taiwan government has to say about the claims made in South China Sea. I think everything started from 1947, which Dr. Hono has said, that there's a map that everybody knows, that the map is called the location map of the South China Sea islands. So there are at least, the map is at least a territorial claim, and nobody disputes about that. But the question is whether the map or the U-shaped line appearing in that map means something more. So, but if we can consider the South China Sea policy guidelines released by Taiwanese government in 1993, the preamble of that South China Sea policy guideline says that U-shaped line is a historic water, the outer limits of historical water. So that is the claim made by Taiwan, much more aggressive than Beijing. This South China Sea policy guidelines was suspended in 2005. So people might think that Taiwan abandoned that claim so that Beijing cannot use that. However, we have to pay attention to what happened in 1999 in Taiwan when the ROC government released the first group of baselines and outer limits of territorial water and contiguous zone. Because in that first group of announcement, U-shaped line was called inherent boundary line. So you can imagine that in the time of 1999, the South China Sea policy guideline was still effective. So the idea of U-shaped line as outer limit of historical water has been transferred or has been a part of this first group of baseline and outer limits of territorial water and contiguous zone. And until now, it is still effective. Now, also very important is what the President Ma Ying-jeou said last year, September 1st, in our exhibition of Southern Border Historical Archives held in Taipei. President Ma's opening speech was reported by The Economist, which said that President Ma explained the 1947 map was published when China only claimed territorial water and nothing else. Later on, one month later, the head...
Sorry, I don't want to cut you off, but you're coming close to your 12-minute speaker limit. I wonder if you might be able to wrap up in 60 seconds with either a question or a conclusion.
Well, I'm not going to talk about this in my speech next session, but I feel that the people need to know what Taiwan, as the ancestors of Beijing, claims about.
Excellent. That's 45 seconds now left.
Okay, please pay attention to the South China Sea statement released by MOFA in Taiwan on 7th of July this year. Thank you.
Thank you. Well, I'll invite general comments up and down the table, starting to my extreme.
Okay, I would agree that the South China Sea claim was left by ancestors, but I would suggest that those ancestors lived in the 1920s, not 3,000 years ago. It was a result of Chinese nationalist desire to modernize the image of China from a dynastic imperial system which didn't have formal boundaries to a Westphalian idea of a state with formal boundaries at a time when the country had been attacked by imperial powers and had obviously lost territory. And you have a complete confusion in China in the 1910s, 20s and 30s about where its proper borders lie. And it's interesting that on every land border, China has settled a frontier, with the exception of 2 spots in India. But on every maritime frontier, China is in dispute. And it's because on the land, states pushed back and agreements were made. But on the water, nationalist dreaming could continue. And so this is why the disputes linger there. A map is not a territorial claim. In 1933 or 35, the ROC Interior Ministry had this inspection committee to try and regularize the maps. And it took its inspiration from maps that had been drawn up by private individuals, the Shanghai Cartographic Society, the China Geographical Society. The map I showed was produced by a private company, the Zhonghua Book Publishing Company. Okay, these were attempts to educate the public. And this idea about China's rightful borders, it moved from the private sector into the state sector in the 1930s. And initially in the 1930s, China decided it had no claim in the Spratlys. But the belief that it had protested against the French claim somehow slips into Chinese government thinking. So Chris Chung has shown that in the discussions in 1946-47 about the map, the bureaucrats there believe that China issued a protest against the French in 1933 when there's no evidence that they did so. So what we have is people who are in very difficult circumstances in a time of war trying to come up with a framework for a modern nation state and unfortunately doing rather a bad job of it. And that's the legacy that we have today.
2 comments, one to Bill, and I'm not a historian, so I'm not in a position to question the evidence that you showed to us. And if I myself, I look at, for instance, the British archive and the French archive, and I know there was an Irish professor who actually come up with a different conclusion than yourself. So I'm thinking like newspaper mapping, and also equally important is also look at the archives. So what he did is compare the Chinese archive with the British archive and the French archive, and I'm going to read there's a literature and they provided, and then trying to compare what these Irish professors' conclusion from the comparison of three archives, national archives. And then the second comment back to Professor Gao's explanation about Chinese claims. I think it's have to differentiate the historical evidence than historical right. I think Chinese claims of the sovereignty over Paris and Spratly is based on the historical evidence, which has an important support of international, it's a legal evidence by customary international law, by first discovery and mapping, and also a prescription and effective control. And then that is different from my explanation about historical water and historical right, which are signed by our organizers. I think what needs to be understood from Chinese perspective, or obviously there's no official explanation what is the legal state of the U-shaped line. And in China, there are different schools of thought. Historical waters and the maritime boundary. I think the most moderate claims, as far as I understand, is sort of historical rights. I think what I'm trying to do is to provide what could be China referring to, although it does not make very clear it's historical rights. What I want to do is try to explain to you what kind of historical right that China might be able to claim, and also I'd like to also provide the differences between historical rights and also other historical concepts. And what I also wish to reach out is to actually how to reconcile the historical claims versus the modern claim based on EEZ and continental shelf. I think on the one hand, you cannot simply say that, well, because we have this new concept of EEZ and continental shelf, and for the historical claim just go away. And it's a little bit unfair to say that. On the other hand, I think it's also unfair for China to say, well, because we have the longest history in this region, and then we have to consider whether you have full entitlement of EEZ and continental shelf. I think those two extreme views is not something that we should follow. I think we need to find a balance, and we need to actually find something that is acceptable for both interest groups in this region. Thank you.
Thank you. I'll just say one thing, which is I refer back to a comment I made at the beginning, which is that it is not possible to have sovereignty over the water apart from the territorial sea. So until the Law of the Sea Convention came up after many decades of negotiation amongst countries with the idea of having certain economic rights beyond the territorial sea, there were two zones in international law. There was the territorial sea and there was the high sea. So the idea that there can be a historic claim to waters beyond 3 nautical miles before the UNCLOS Convention is another one of these historical myths. It just cannot be, as a matter of fact. The other thing, I always hate to do this. One of the things I do is I teach the International Law of Boundaries at King's College to a multidisciplinary group of students, i.e. not lawyers, so geographers, historians, economists, and so on, international relations experts, and they all are always deeply disappointed when I give the lecture on evidence in international law, and they learn that maps are pretty, but almost entirely meaningless.
Yeah, thank you. Maybe just, I'm afraid I disagree with you concerning the fact that historical rights cannot exist beyond the territorial sea. I think there's a lot of practice which suggests the contrary. For instance, sedentary fisheries beyond territorial sea. So I think that's a question for further debate. Maybe another point on historic rights, which also was referenced by Dr. Hong. I think it's very important to ask ourselves what those historic rights may consist of. And I think in that respect, it was also interesting that there was a reference in Dr. Hong's presentation to the Barbados and Trinidad and Tobago arbitration. And I think that in that case, the the tribunal was very careful in distinguishing historic fishing activities and present-day fishing activities, and saying that the fact that there is a continuation of activities does not mean that existing historic rights are of the same nature as the present-day activities which are carried out. So you have to be very careful, I think, in looking at what kind of activities really are we talking about. And I think so that's a starting point for asking yourself, what are these historic rights which we are talking about?
There was a question, yes.
Thank you, Chair. My name is Hao Zui Fan. I'm Senior Research Fellow at the Center for International Law, National University of Singapore. I thank you all speakers for your presentation. I have a common question to Professor Elferink and to Dr. Nong Hong. To Professor Elferink, you mentioned in your presentation the case between Tunisia and Libya, right? However, it should be noted that in that case, the court concluded that the issue of historic rights is not relevant to the proportionality test. It should also be noted that in the case, the judgment was rendered before the adoption and entry into force of UNCLOS. Now, the entry and the adoption and entry into force of UNCLOS means that the coastal states have sovereign rights and exclusive rights to the EEZ and continental shelf. It is true that according to the preamble of UNCLOS, matters that are not governed by the convention continue to be governed by general international law. However, the EEZ regimes and the continental shelf regimes are clearly regulated by UNCLOS. Even traditional fishing practice is also regulated in UNCLOS, specifically in Article 62.3, which provides that the coastal states shall take into account the habitual fishing practice of other states in giving surplus to other states in its EEZ. And it should also be noted that during the negotiation of UNCLOS, there were proposals to recognize historic fishing rights in the EEZ of the coastal states, and these proposals were rejected. So my question to you is, what would you think of the implications on UNCLOS and its EEZ and continental shelf regime if states are allowed to make historic claims in the EEZ of the coastal states? What would be the implications? And Dr. Nong Hong, you said in your presentation that the most convincing historic rights that China could claim may be fishing rights, right? That's your view, but we are still not clear about what the official position of China. I mean, I'm not sure whether China is claiming historic rights to fishing, or are they claiming historic rights to oil and gas? If they are claiming rights to oil and gas, then what are the evidence of traditional practice to explore and exploit oil and gas in the South China Sea? Are they claiming also the rights to regulate marine scientific research? Are they also claiming the rights to regulate artificial islands in these U-shaped lines? I mean, it's not clear what the rights that they are claiming. And if, they cannot make clear of the rights that they are claiming, how can these rights be recognized and accepted under international law, right? And China has recently, on many occasions, upheld the principle of land dominates the sea. More recently, in its position paper against the Philippines, in the Philippines vs. China case, China supported the principle. So, on the one hand, China supports the principle of land dominate the sea. On the other hand, it makes maritime claims that are not based on land. So, are they contradictory to each other? And if China claims historic rights in the EEZ and the continental shelf of another coastal states, can other states also explore and exploit natural resources within what is clearly within the EEZ of China? Thank you.
Yeah, thanks. Very interesting question. Raised a number of issues. I'll just go go along them one by one. First of all, you mentioned that the historic rights were not found to be relevant for the proportionality test. Well, that may be the case, but I think that is in no way relevant for the dictum of the court on the relationship between the convention and general international law and how these two deal with historic title and historic rights. As regards your second point, that the case was before decided before the adoption and entry into force of the Law of the Sea Convention. I think it was of course decided at the time when the at least the draft convention or the single a very advanced stage of the single negotiating text was already available. So I would say that the fact that the convention was not formally adopted yet also is not significant for this finding of the court. The court had the convention before it, basically as it later was adopted. So I think that you cannot say that because the convention was adopted later, the court would have reached a different decision if it would have had to rule on this question at a later stage, because it was specifically invited by the parties to also take into account the trends at the third United Nations Conference on the Law of the Sea. Well, then your reference to Article 62.3, well, you of course refer to the fact that there is a reference to habitual fishing practice, and that's of course something different from historic rights, I would say. And I would say, I didn't look in detail at the drafting history of the convention, but I'm also not sure that these references in negotiating record to historic fishing rights in the exclusive economic zone equal historic rights to maritime zones. But I agree, I have to admit I have not looked at that into detail, so I should look into that further. So thanks for bringing that to my attention.
Well, thank you for your question. That's a very professional question, asking about what is Chinese position, whether it only claims your rights purely only on fishing, or there's other definition or category of historical rights. Obviously, I don't have an answer from the government, but I think the two concerns that you just raised, I think even without providing you the official statement from the government, I'm able to release your concern about that. Well, a part of that, I don't also have a difficulty in fighting state practices in terms of exercising his rights on oil and gas resources. But your question, your concern about whether, or if China claims your rights in the South China Sea, whether they're going to have regulation on artificial islands, and I think that is not something that we should worry about, because the artificial island is clearly, firstly, it won't actually change the sovereignty claims. It would not actually also have an impact on maritime delimitation, and it would not actually change the legal state of particular features. And I think the regime of artificial islands is governed on Article 60 of the Law of the Convention, so I don't think there will need to concern about it. And China would not take different approach in terms of how to manage the artificial islands than other states' practices. And about the marine scientific research, and I think all these coastal states, and they have a domestic regulation, and I don't think this is that China will actually, put a hand on that. And another question about the infringement of historical claims in other countries' EEZ. I think if I look at the previous, for instance, case law and state practices like Echo and Yemen case and Yamarian case, and also this India versus Sri Lanka case, and there's a tendency that the courts actually tend to recognize the historical rights of some countries, although the historical rights may not actually affect or may not actually make the courts to justify the maritime boundary to a very large extent, but actually the court actually take into consideration of historical rights. And then about the question of and how do we actually concise our rights versus EEZ, I think the arbitration court actually will having difficulty of actually taking into consideration his rights, and the most practices is for the countries actually to coming to, rather than fighting against, to adjusting the boundary. Instead, they're actually working on, through bilateral agreement, on how to go for the conservation of fishing resources in the on the overlapping claims versus the historical claims and EEZ. I hope that answers your question.
Yeah, I mean, I think maybe more important than the historic claim, China has an emotional claim to the waters of the South China Sea. And that's really what this is about. And I think it's interesting, I think, because people like Hong Kong are trying to fit the emotional claim into the straitjacket of international law, which is much better than just saying it's ours, we've got lots of ships, and that's the end of the discussion. It's part, I think, there is a pushback against the idea of the free sea in many parts of the world. I mean, the US is in dispute with Vietnam about regulations of its exclusive economic zone, and Malaysia, and India, and Brazil. It's not just China. So there is a move against some of the tenets of the free sea. But at least the mainland is trying to think about what it can claim in terms of UNCLOS, and I think the Chinese official response to the transit of the USS Lassen, to me, certainly showed signs that the government in Beijing is trying to argue more within the terms of UNCLOS than outside it. It's not specifying 12 nautical miles, but it's saying adjacent waters, relevant waters. It's not claiming sovereignty over the U-shaped line in those official responses. So I think these are good things. Now, what would be really helpful is if Taiwan could modernize its attitude to the law of the sea and actually start bringing its claims into line, and that would help everybody by saying, going back to you've got the archives, the 1946-47 archives, go and see what they actually said, and it was about claiming the islands, it wasn't about claiming the waters.
In fact, to my opinion, all coastal states in the past have the historic right of fishing in their near shore. And for the case of China, historic evidence shows that Chinese are very similar to the North Vietnam. We are not the sea state. And in the past, the fishing of the China is very limited to the near shore. And in central Vietnam or other states, for example, the Philippines, they have the historic right. Also, they practice the fishing in very far from the shore. So this means that not only China has the historic right of the fishing, but all other countries surrounding the South China Sea also. So that one, I think, should invalidate the U-shaped line. Thank you.
Thank you very much. Of course, I think all the comments make it clear that from a legal point of view, it's important to pay attention to the precision of language, so that there is conceptually a difference between something that is a historic bay, between a historic title when looking at the limitation of overlapping 12-mile territory seas, and historic fishing rights. And you look at, for example, the Eritrea, Yemen, and Barbados, Trinidad tribunals, and they made it clear that historic fishing rights have to be taken into account, but don't affect the limitation, that is, who has what. And also it's important to remember, as the professor said, there's a distinction between claims to title to territory over islands and claims to use and so on of maritime space. They're different things, and in the South China Sea, I think the talks this morning have brought out the fact that these, if these concepts are all mishmashed together, you're just going to get confusion. There was a question, a very patient gentleman at the back.
Thank you, Mr. Chair. My name is Guanxiong Wang from National Taiwan Normal. My name is Guanxiong Wang from National Taiwan Normal University. I have one question and one comment. First, my question is to my Vietnamese friends, Dr. Vu Thanh Ga. I agree with you that you mentioned that the biodiversity, fishery resources, and the environmental protection is really important in the South China Sea. And also, I agree with you that we are lack of the a kind of ocean governance mechanism in the South China Sea. So I would like to ask you, do you have any further designation about what we are going to do in the future to protect our ocean for the region? And secondly, my comment is to Mr. Bill Hayton. I agree with you that the evidence is important in the study and the research. I have two further information for you. Probably that is could be a kind of supplement to your study. First of all, you mentioned about Bai Mei Chu. He drew a map calling the New China Construction Map. However, according to my understanding, Bai Mei Chu, he was a professor in Beijing in the 1910 or 1920. And so the map he drew, I don't think that will be a kind of important evidence for the official meaning. And secondly, that is the talking about the 1933 incidents on the French occupation of 9 small islands in the South China Sea. According to my understanding, there are several diplomatic exchanges between the government of the Republic of China and the government of France in that period. And for those documents, we had already opened to the public in last year the South China Sea Archive exhibition in Taipei. And also we published a collection for those archives. So if Mr. Bill Hayton or any friends in this room, you are interested in those archives, I think we can Google that and find out that book. Thank you.
Thank you for your question. So I would like to say that according to my opinion, the most effective mechanism for governance the South China Sea is a partnership. It means that we establish a partnership council concerning all the states surrounding the China Sea who have interest in the governance. And also, we can invite to the partnership council the institutions, international institutions that interest in participating in this process. And we can have a coordinating body. And the coordinating body shall help, for example, workshops and all other meetings and also research to determine which we to determine the mechanism of coordinating in this case. And the most important is the issues of disputed disputed water must be addressed. So at first stage, I think we can determine the temporary boundary of each coastal state based on the UN clause. That one is a very simple determination and not really the real boundary on the sea. And we determine the disputed water. And for the we shall reach agreement between member states about the mechanism for governance, and all the agreement should be internalized into the institutionalized into the internal laws and regulations for governance of the coastal, because the South China Sea is an entire South China Sea is an ecological system. So we should govern it or manage it for the entire ecological system. And we so in the maritime area under jurisdiction, so coastal state should apply the agreement to their water. And for the disputed water, so all parties involving in the dispute need to agree on the mechanism of governance based on the agreement of all partners in the partnership council. Thank you.
Okay, my argument is that you won't see this very well, but this is done. The map I showed you, the map of national humiliation. There are many, many others. Okay, this is one from 1916. Here's one I don't have a date for, and then here's the 1927 one. Okay, there are many, many such maps. Now, my argument is that the origins of the U-shaped line arise from the private sector, from individuals and nationalists and civic society trying to define China's borders. And then those ideas move into the government sometime in the late 1930s, 1940s during the war. Now, we don't know how that process happened because nobody's done the research, how this was communicated. But if I give you one example, a guy called Professor Zheng Ziyu, I probably mangled the pronunciation, was another geography professor in the 1930s. And he was hired by the Ministry of Interior. There he is, okay? He was hired by the Ministry of Interior, and there you can see him on the 1946 expedition to the Paracel and Spratly Islands. He was hired by the Ministry of Interior to draw up the maps and to guide the expedition. Okay, so he's an academic who is in the working in a university. He's hired by the government to draw up the U-shaped line, I think. Now, I'm not 100% sure of this, but this guy, I believe, is the person who drew the U-shaped line. He was the one who drew what was called the location sketch map, which you can find in the Taiwan archives because it's helpfully online, and I've looked at it, and it's there, okay? And it's even got spelling mistakes. It even mixes up, the Zhengmu Tan, the Zhengmu Ansha. It gets the names wrong because it's a sketch map, yeah? And it's on your own archives. You can find it. Now, when it comes down to 1933, I've had a Taiwanese researcher go through your archives and go through the back issues of Shenbao newspaper. Okay? Yes, there are protests in the street. Yes, there is confusion. Yes, there are government statements. There is no formal government protest because in July 1933, the ROC government in Nanjing didn't know where the islands were. So it sent a telegram to its consul in Manila, Mr. Quanling Chung, I believe his name was, and he had to ask the Americans for a map of the South China Sea and ask the Americans to tell him where the islands were that the French had annexed. And when the Americans told him that those islands were in the Spratly Islands and not the Paracel Islands, then the Chinese realized they didn't have a claim and they did not issue a protest. Now, if you can find anything that contradicts me, I will change my view. But until then, I'm sticking to my view.
Thank you. We're running to the end of our time, but we started late because everyone was drifting in from breakfast and coffee. So I'm going to use my prerogative as chair not to cut us off for a few minutes in the event that there's someone with a question. We've got time before the next session. Have I missed anybody? There's someone here, yes. But given time and people's interest in coffee, let's try and keep these quite short. And there's another one over here. So please. Thanks.
Yes, you. I haven't got a microphone. We're very interested in Taiwan. There's an election coming up in January, and it looks okay.
Cameron Mitchell, HSBC. There is an election in Taiwan coming up in January, and it looks increasingly likely that the DPP will in all likelihood win that election. I don't want to make any assertions too boldly there, but what happens with the claim? And there is some talk at the moment that the DPP might start to clarify Taiwan's claim in the South China Sea. So the quick questions I have is, one, are they able to do that, considering the claim was initially a KMT claim? And two, if they can, what does that then do to mainland China's claim? Thanks.
Thank you. There were a couple people over here. Yes, one and then two.
Okay, thank you, Chairman. I have just a quick comment and also questions. This panel reminds me something like the the phenomena, interesting phenomena is that it seems to us that Chinese claim is always discussed based upon the so-called historical evidence or historical base, and some other claimants around South China Sea based upon their legal arguments, right? But by this panelist, thanks for your presentation that you give us quite a lot of the legal evidence or legal arguments support the Chinese claims. That means China not only based upon the history, but also based upon the legal base. So I would say that, you know, number one, like Hong Nong offer quite a lot about the legal arguments support the Chinese so-called historical claimant. But I don't think that's just Chinese historical claim, but also the legal claim. So that's my point. And the second, regarding the resolution of their disputes based upon the legal framework. So there was common principles, that is their legal approaches and also justice approaches. So like our Vietnamese friends in his presentation say that, you know, China is the biggest fisheries country in the world because so much population of China based upon the fishery, right? Just within these 4 provinces along the South China Sea, like the Canton, Guangxi, Fujian, and Hainan, more than 200 million people, you know, in that area. So the reason why so many Chinese fisheries, you know, taking place in the South China Sea. So please understand the Chinese, you know, some kind of difficult for our population to base upon our fishery industry. So the reason why Professor Hayton said that Chinese claim a little bit emotional by this way, right? So my 2 questions, maybe one question to our Professor Elferink.
Sorry, we are running on time.
Okay.
How about you ask your 2 questions in 30 seconds?
One is, what are your points that always makes the comparison? You already make a comparison between Chinese and the Filipinos' legal argument. But what can we make the balance between the Chinese and the Filipinos' legal arguments? And the second question to our Vietnamese friends, and now we know there are some differences between Chinese and Vietnamese regarding the prohibition of fishery in the South China Sea. But in your points that maybe we need some kind of the common, you know, joint efforts to conduct such kind of the prohibition of fisheries in a years. So what's your comment about this? Thank you.
Thank you, and I think there was one last question down the left.
Thank you, Chair. I'm Lan from Diplomatic Academy of Vietnam. I have 2 questions. The first question for Alex Elferink. In your presentation, you mentioned about the bifurcation between sovereignty and legality of the activities. You also mentioned about the context of maritime delimitation and the obligation under Article 74 and 83, Paragraph 3. Can you make a comment on the prospect of using different mechanism on settlement of these issues? And my second question to Nong Hong. You mentioned about the provision of the 1998 EEZ law of China. Could you please clarify the content of the provisions, and also does it content is in contradiction with the position that China took during the drafting process of UNCLOS concerning the legal regime of EEZ? Thank you.
Thank you very much. I'm going to not take any more questions or comments. We have to wrap up in 5 minutes, so I'm going to ask, it's a bit unfair, each of the panelists to respond to these thoughts and questions with 1 minute each. Otherwise, we'll have very hungry and thirsty people in front of us. So let's just start.
Okay. I think the question was about other arguments by other claimants. All of the other claimants have holes in their arguments, but they don't seem to cause as many problems for the international community as the U-shaped line claim does. That's why we're here, because of the U-shaped line. If China just claimed the islands, we could all go home. Well, actually, the Vietnamese would stay, obviously, but the rest of us would go home. I mean, so there are island disputes. I mean, I have no problems in saying that I think that the ROC has the strongest claim to Ituaba, Taiping Dao. Okay? If the French were still in the game, they might have a strong, they might be able to claim that they were there first. Okay? But ROC's been in more or less continuous occupation since 1946, 56, if you argue it. But the other islands, no. The Philippines have been on T2 for a long time. Vietnam's been on Spratlys. I mean, it's all about the U-shaped line, really, and the gaps in between the islands. That's why we're here. The gaps, not the islands.
I think that gentleman's question deserve an answer, which I would like to refer to the next speaker, Professor Gao, and he can actually explain from the Taiwanese perspective. I don't think I hear very clearly your question, but if I'm wrong, we can discuss later. I think the question is about Chinese negotiation in the Chinese participation on the concept EEZ during the third Conference on Laws Convention, and I might be wrong, but anyway, I think right now this discussion within Chinese scholars that saying that, well, when Chinese ratify Laws Convention, especially standing up to support the regime of EEZ, actually kind of bring to what the dilemma for China today. On the one hand, we have this new regime of EEZ, and the other hand, which might actually contradict with China's historical claims. What I would recommend is actually, as the International Court of Justice says, that when we have this third country's historical claims for infringing to another country's EEZ, the best and the proper way is for the country relevant countries for negotiation. Thank you.
Yeah, thanks. Very brief. Maybe just to clarify one point concerning the Chinese historic rights claim. I was not arguing that it's a strong claim. I don't think that's the case, but I think it's very important in the light also of the arbitration to make a distinction between the claim as such and the possibility that the tribunal may make a finding on it because of the limitations on its jurisdiction. And I think it's very important to keep that in mind. As far as the claims in China and Philippines are concerned, that's of course a very broad topic. I think, generally speaking, you can say that the tribunal likely is to uphold some of the Philippines claims and others not. For instance, I find it very unlikely that they will find that all of these Spratly Islands are rocks which are not entitled to an exclusive economic zone on continental shelf, like the Philippines is submitting. Maybe the final point, 74.3 and 83.3. I think these are very relevant provisions for looking at the issues in the South China Sea, and I'm sure that the governments involved are aware of that. And of course also China itself and also Vietnam has a number of cooperative arrangements concerning both oil and gas and fisheries, and I think that practice could also be put to use in the South China Sea. Thank you.
Yes. Regarding the question of Professor Chua, I would like to say that in fact Vietnam and China has a fishery pact in the Tonkin Gulf, but I think that pact is only a part of can solve very, very small part of the problem. As I said that the South China Sea is an ecological system, and it should be solved entire over the entire South China Sea. So I think that we need to invite all coastal states surrounding South China Sea participate in these efforts. Otherwise, our efforts is not successful. Thank you.
Well, I thank the panelists very much for being concise in their wrap-ups. I'm sorry if there are any questions that were not addressed. I think we have had a learned and thoughtful, helpful and stimulating panel this morning, and I ask you all to help me thank them in the usual way.